Okay, hello everyone. We are very excited to have you join us today at this sixth and final session for the Rio Grande webinar series. This series, as you know, is organized by the Permanent Forum of Binational Waters and UCLA. These sessions are going to be made available to you at some point. Rosario has been working on this. And in about a couple of weeks, we will launch the next webinar series, and that's going to be in Europe. It will focus on Guadiana River Basin. It's a transboundary river basin between Portugal and Spain. So we have interesting stories to share with you as well. And with that, it is my great pleasure to introduce our speaker for today, Professor Gabriel Eckstein. Just quickly, Professor Gabriel Eckstein is a professor of law at Texas A&M University, where he researches and teaches on water, natural resources, environmental law, and policy issues at the local, national, and international levels. He regularly advises UN agencies, governments, NGOs, what have you. He has represented nations before the International Court of Justice. He chairs the Executive Council of the International Association for Water Law and is the immediate past president of the International Water Resources Association. He also serves as associate editor for the book series Brill Research Perspectives, International Water Law, and he's also on the editorial board of the Journal of Water Law. In terms of his educational background, he holds LLM in International Environmental Law, a JD in Law, MS in International Affairs, and BA in Geology. So he really has interesting educational background, covering both physical and social sciences. So with that, Professor Eckstein, please take the floor. Thank you.
Thank you so much, McKenna, and thank you to you and to Rosario for inviting me, and thank you to the UCLA Samueli Civil and Environmental Engineering Program and the Permanent Forum of Binational Waters. This is a real treat for me to participate and engage with all of you on the Rio Grande. It's a fascinating history and events and occurrences and relationship between the U.S. and Mexico. And there's so many angles to it. And I'm glad you're doing this series because there's so many perspectives and angles to look at on the Rio Grande. And it's definitely worth this kind of treatment. What I'm going to do is I'm going to focus primarily on the sort of the legal and policy issues, governance sort of writ large in my presentation. I'm going to briefly start with just a little bit general setting, which I think the other participants in this series already did. So I'm only going to spend one quick minute on that. But then spend a lot more time on the legal setting, and just to give everybody a sense of what's the legal and governance system for this transboundary basin, this international river basin. And then I'm going to go, again, briefly on general challenges from a legal policy governance perspectives, challenges that are that have been ongoing for probably decades, if not longer. But I'm going to highlight 4 specific challenges that I think are very prominent right now and important to consider. So I'm going to see if I can get my screen to share, and I'll get started. All right, so hopefully you can see my screen now. Yes, good. Okay, so real briefly, sort of a background, general setting. Not going to spend too much time on this. This is a transboundary basin, fairly large when you compare it to other river basins around the world, 336 square miles. The river itself is about 1,900 miles long, but the important part here is that a substantial amount of it, over 1,200 miles, actually forms an international border. And what's distinct about this is this next part is that it's shared by two countries. So at this point, you have to start thinking about it. Well, what does it mean that two countries share a river basin? How do they allocate it? How do they split it? Who gets how much water? And note also that here the river starts inside of the U.S. and doesn't go into Mexico, but rather forms the border of Mexico. So what does that mean for law and policy? And then thirdly, it's not just the U.S. and Mexico. You've got 3 American states. You've got 4 Mexican states involved here. And what does that do to the legal relationship between the two countries? What does it do to policy setting, to decision making? So this kind of background has to be understood in not just in the context of the science or the social issues and the cross-border technical management, which is very critical, but also in the context of this legal setting in terms of rights and responsibilities, obligations, what you can do, how much you get, and so on. So this is, I think it's enough of a sort of general setting, as I know that the other speakers in the series kind of covered this in much more detail. So let me move on to more of the legal setting. And by legal setting, I'm going to start with this international level where you have two countries, and I'll bring in the states in just a little bit. But at the state-to-state level, you have quite a number of treaties and conventions. Conventions is just another word for treaty, between the U.S. and Mexico in terms of how they're going to manage these transboundary rivers, transboundary waters. It starts all the way from the Guadalupe Hidalgo Treaty from 1948. And the most recent one, which I don't have on here, is from 1970. There's a treaty between U.S. and Mexico to address some corrections in the border. A river is a dynamic system. It moves. It grows and shrinks. You have droughts, you had floods, the riverbanks move. 1970, they had to actually have an agreement on some modifications to the border because the river had moved around. And so there's all sorts of agreements that are in place between the two countries in terms of how this river is to be managed. The two that I particularly want to focus on are these last two from 1906 and 1944, because these are the ones that actually talk about allocation and rights and responsibilities specifically to the water and to the river itself, and how the two countries are supposed to relate to each other. The 1906 convention focuses primarily above Fort Kittman, just below El Paso and Ciudad Juarez, and up. So really the upper part of the basin. And the 1944 treaty is the lower part of the basin. So as we start with this 1906 convention, this is really to distribute the water, as I said, above Fort Kittman in the upper basin, just to decide how much water you get. And you have to think about this map here. The river is coming in from Colorado, which is up to the top, goes through New Mexico, and then hits the border. So there's a question of, well, is this U.S. water, or is this already international water when it's in New Mexico? It hasn't hit the border yet. Well, this agreement talks about that, and it does recognize that this is still a transboundary international river, and therefore there are some obligations on the U.S. side to ensure that some water gets to Mexico. Otherwise, if the U.S. would drain the water before it reaches the border, there would be nothing to flow in this portion that's at the border below El Paso and Ciudad Juarez, which I think would be to detriment of both sides. So what this agreement does is it obligates the U.S. to deliver 60,000 acre-feet of water every year to Mexico at a head gate, which is located just down here on the border. Now, I don't know if you can see my mouse kind of circling, but it's right where it's just above where it says American Diversion Dam, International Dam, and so on. Now, this 60,000 acre feet of water, what is an acre foot? An acre foot is, if you picture a football field, all right, an American football field, and you fill that football field with 1 foot of water, that's about 1 acre foot of water. So if you get 60,000 of these football fields, that's about how much water the U.S. is obligated to deliver to Mexico in the Rio Grande. Now, how do they do that? Well, they build up storage. You have Elephant Butte Dam. That's the upper blue piece or lake that you see in the map. And then there's also just below it Caballo Dam. That's where they're stored until they reach, they have enough water, and then they can send it at the right time of year when the agreement specifies. So that's part of the agreement is that U.S. will store that water there until it's ready to be delivered. But interestingly here, there is a provision in the 1906 convention that allows for reductions, proportional reductions, in case of some kind of big drought or there's some kind of infrastructure problem on the U.S. side. Why is this important? It's important because this particular feature does not appear in the next treaty, which is the 1944 treaty. So the 1944 treaty distributes water between Mexico and the U.S. below Fort Kittman. So this is the lower part of the basin. It allocates, has a somewhat complex allocation system in terms of all these tributaries that are coming into the main flow, the main channel of the Rio Grande. And they have an allocation system where certain tributaries are 100% for the U.S. and certain tributaries are 100% for Mexico. And then some additional tributaries are divided 2/3 for Mexico, 1/3 for the U.S. This was done back in the 1940s when they were trying to quantify how much water is actually flowing from all these tributaries into the main stem, the Rio Grande, and they decided on this allocation scheme. So it's not simply unfair because they get more tributaries, we get less tributaries. They actually tried to quantify how much water was coming down those tributaries, and that's where this division comes from. And I'll show you a map in just a second that maybe makes this a little more clear. But deliveries from to the U.S. from the 6 Mexican tributaries, remember the ones that are allocated 2/3, 1/3, there is a provision in this treaty that says that it has to be at least 350 acre feet averaged over 5-year cycles. So you can have less than 350 acre feet in a particular year, but over a 5-year cycle, it has to average 350 acre feet annually for a total of 1,750,000 acre feet over that 5-year period. Remember the provision I mentioned in the 1906 treaty? It's different in the 1944 treaty. If we have this extraordinary drought or some kind of infrastructure problem on the Mexican side, there is no proportional reductions in this treaty. Rather, Mexico is obligated to make up those deficiencies in the 5-year cycle that follows immediately after the one in which they have the deficiency. And this is one of the problems one of the challenges that I'll talk more about in a little bit. So this next slide is to give you a sense of, maybe a better sense, a picture of who gets what water. You have the black is the main stem. You've got the Amistad Reservoir and Falcon Reservoir, the yellow circles or ovals. On the far left, you said 60,000 acre feet delivered from the U.S. to Mexico. That's the 1906 treaty. And then a little further down, you have all the tributaries divided. The ones in green are the ones that are divided 2/3, 1/3 between Mexico and the U.S. The ones in blue are 100% of the water goes to the U.S. or is allocated to the U.S. And the ones in red at the bottom, Rio Alamo and Rio San Juan, those are allocated to Mexico, 100%. So that sort of gives you a little bit of the legal setting at that top level. I'll talk a little bit more about at the lower level, at the state level in just a minute, but just to give you a little bit more background here in terms of the challenges that have been faced in the context of a legal setting. Well, actually, I think my slides here are a little disorganized. There we go. So I am going to go into the specifics here of the legal settings. All right. So at the top level, we have an agreement between the U.S. and Mexico. So Mexico has an allocation that it received. We just saw from the last slide approximately how much, which tributaries it receives. The U.S. gets its tributaries. Once it receives that water, Mexico then decides how it wants to use that water within its domestic system. And in Mexico, we have a centralized decision-making system. It's top-down. CONAGUA is the ministry that is responsible for water management in the entirety of the country. And the water that's allocated under those two treaties, 1906 and 1944 treaty, they get to decide effectively, well, who gets how much and where do they get that water? On the U.S. side, it's a little more complicated. The U.S. has what I would say a decentralized decision-making and water allocation system, meaning that, yes, the U.S. gets that water based on these two treaties, but at the federal government doesn't make the decision of who gets how much from the tributaries on the U.S. side, how much from the main stem, and so on. That's not a federal decision. Rather, it becomes a state decision. And as I said, we have 3 states here: Colorado, New Mexico, and Texas. This water effectively becomes theirs to decide on. But of course, well, how do you decide between the 3 states who gets how much? This is an allocation to the United States, but these are the 3 states that are going to be using it. Well, how do we decide between those 3 states? They enter into their own agreement, their own mini treaty. We call it a compact between Colorado, New Mexico, and Texas. And they decide how to allocate the water of the Rio Grande that had been allocated to the U.S. And they then decide how to divide it between those 3 states. And in fact, this particular compact is now under litigation in front of the U.S. Supreme Court because Texas is alleging that New Mexico is not abiding by the compact in its obligation to deliver water to Texas from New Mexico to Texas. Remember, this is all under the agreement between U.S. and Mexico. U.S. gets a certain amount. The states decide how to divide up that amount. Texas is saying that New Mexico is violating this agreement between them, this 1938 compact. But then once each state gets its allocation, and if we can figure out this lawsuit between Texas and New Mexico, then what happens is each state gets to decide what it wants to do with that water based on its own state laws. So those tributaries, the Devils, the Pecos, and so on in Texas, those are allocated to the U.S. Under the compact, those are allocated to Texas. And then under Texas law, they have a system called prior appropriation, and they divide up the water to whoever has a prior appropriation permit. Complicated. On Mexico's side, remember, CONAGUA decides. Anybody who wants to receive water, get water, on the Mexico side, they have to go straight to the federal agency. There's no state involvement. There is some consultation. There are some basin organizations and irrigation district organizations on the Mexican side, but the level of participation is very, very limited, and certainly very, very little, if any, decision-making at that low level. So very different systems. On the U.S. side, allocation has really become a on-the-ground, state-by-state decision. In Mexico, it's a top level at the federal level. In addition, we also have this institution here, the International Boundary and Waters Commission. So we have the federal government, we have the Mexican government, we have the state governments on both sides, although on the Mexican side, they're not very involved with decision making. On the US side, we have a lot of decision making at the state level, but we also have this binational entity that has authority because of the treaty agreement between the US and Mexico. So at that federal level of the two governments, they created this binational institution to address at that binational level, nation-to-nation level, any kind of problems, disputes, controversies, and top-level management. So the International Boundary Waters Commission is this commission. They're structured in a way where they have very similar internal structures in terms of having a commissioner, secretariat, engineering staff, legal advisors, field offices, and so on. And they're under their respective sort of foreign ministries. In the US, we call it the State Department. In Mexico, it's called the Foreign Ministry. And they are responsible for these top-level decisions and for ensuring that the treaties are followed and that the treaties are abided by. And there are provisions in the treaty that require monitoring and require enforcement. That's at that top level, not at the who gets how much water to use for agriculture, who gets how much water for a factory. That's at that's at a domestic level. One of the mechanisms that they use, and they have used, I have to say very effectively, is a provision, I think it's Article maybe 26 in the 1944 treaty. It's the Menet system. This is unique internationally. This Menet system allows the International Boundary Water Commission, the commission, to interpret the 1944 treaty in relation to new needs, new circumstances, new experiences, new requirements. Now, it's a little awkward here because these are supposed to be interpretations of the 1944 treaty in order to implement the treaty, not amendments. And arguably, I think there's a very good argument that some of these minutes may have done more than just interpret. But as a legal matter, they're supposed to just interpret the 1944 treaty. So, for example, climate change. Climate change is certainly nothing says in the 1944 treaty or any of the treaties between US and Mexico on the Rio Grande or Colorado River, any of the rivers. They don't talk about climate change. But we understand that that's something that we have to deal with, whether you call it prolonged drought, extraordinary drought, climate change, we have to deal with it. And so how do you interpret the 1944 treaty to address things like these extended drought conditions? There is a provision that talks about extraordinary drought. It's not defined, but this is where the commission can step in and start interpreting aspects of the treaty and develop these supplements. I don't want to say amendments because legally that's not correct, but in some cases I actually think that they do go beyond the scope of the treaty and they actually amend the 1944 treaty. There are now 300 and I think it's 325 or 326 of these interpretations, and the way they work is the commissioners, you see Commissioner Salmon and Drusina, these are the former commissioners, and I think this is when they signed Minute 319, which is a pretty significant minute. They come to an agreement, they vet them behind the scenes, they come together, they sign them, and then they send it to the Mexican Foreign Ministry and the US Department of State, and either those entities sign off, approve those, or they do nothing. If they don't do anything for 30 days, it's effectively approved. Now, if they step in and say, no, we don't approve, okay, then that minute doesn't get approved. But typically what happens is there's a lot of background work, and by the time we get a signature, they've already talked to the Foreign Ministry and the US State Department to make sure there's no concerns with the proposed minute. And so occasionally the US State Department, maybe even the Foreign Ministry, it's not that they don't necessarily want to approve formally, but they don't want to disapprove. So they'll just sit back and just let it happen. Within 30 days, unofficially, officially becomes approved, even though without a formal process. And there have been a few disagreements between the U.S. State Departments and the Commission, for example, where the State Department wanted to distance themselves from a decision of the Commission, but the way they did it was by not approving but not disapproving and just allowing the minute to take effect. So this is an incredibly effective and, I have to say, progressive mechanism that I don't know of any other river basin around the world or commission or river basin organization that has this kind of system. But it really allows flexibility and really allows a treaty that is now, 80 years old, more than 80 years old, to adapt and to deal with new realities. There are arguments that the 1944 treaty, maybe even the 1906 treaty, need to be updated or improved to address things like climate change more directly. It's really hard, especially in the U.S., to get a treaty through the U.S. Senate. Having these kinds of mechanisms are absolutely amazing process, and I think this is something that we need to attach to other future treaties, these abilities to interpret them in light of future scenarios. So now let me go to some. So with all this background on the law and the framework, let me go into some of the general concerns and challenges that we see on the basin. I'm going to spend a few minutes on this and then go to more specific ones that I think are today the big issues. I mentioned the border issue. There's a treaty from 1963, and then I mentioned the one from 1970. The river moves, and sometimes you have islands forming because of low water, and sometimes because the islands form because of the sand deposits on a particular bend in the river. Who owns these new islands? Or what if the river moved 2 feet, 5 feet, 10 feet? We've actually had communities that have had to be relocated in the past because the river has moved so much that we weren't sure where the border is. And so we've had these issues resolved. It's an ongoing system. The river is a dynamic feature. It's going to continue moving and shifting. And this is something that will continue to be addressed. But I do think that the 1970 treaty gives us a forward-looking framework to deal with this. Climate change, I mentioned. There's nothing in the treaties that really talks about climate change or drought over this extended period of time or over-extraction. They're trying to deal with it through these minutes, interpretations, but this is something that is going to continue to be an issue that they're going to have to deal with either through the minute system or through some other mechanism. Economic growth, population growth, and on the other side, a reduction in the amount of water because of climatic changes. This is something that, again, the treaty doesn't talk about, but the minute system has been dealing with it and will have to continue dealing with it because this is going to continue to put stress on the basin. Pollution, we've got industrial growth, we have the maquiladoras, we have all sorts of activities going on. And there's serious concerns. Again, these are things that have been going on for decades, and that's why I'm not going to stress these right now. Flood events and then lack of resources. This is perpetual on both sides. On the U.S. sides, we're probably better resourced than on the Mexican side, but even on the U.S. side, there's a, I have to say, profound lack of attention from the federal authorities on what is happening on the border. They have, of course, they have all sorts of other issues to deal with, everything from migration and drugs and trade and so on, to deal with pollution on the border or water quality for municipalities, not always a priority. And so it is under-resourced on both sides. So these are sort of some of the general challenges that I see that are they're going to continue to be with us for a long time. They have been, and they're going to continue. But I want to address 4 particular issues that I think are Some of them have been around for a while, but they are really important right now, and they're going to continue to be, I think, more of the front page kind of news. You know, the lack of resources, the pollution. Unfortunately, they're not going to be front page. They should be, but they're not. But the ones that are going to be front page, I think the Mexico water deliveries, it'll continue to be front page news because I have a concern that Mexico will continue to have problems meeting its delivery obligations. Not because of anything bad that Mexico is doing, not because that they are intending to violate the treaty, but because of climatic changes, precipitation, lack of precipitation, decline precipitation, economic growth on both sides, but certainly also in Mexico, they need more water. They need to produce more agriculture. They have more population. And so there has been now, up until about 1995, 96, 97, Mexico always met its delivery obligations. But in the late 90s, we've now have had 3 5-year cycles where Mexico has had trouble meeting those obligations. And I think this is going to be an issue into the future. Why? I think there's a number of reasons. I think structurally the treaty is vague in the sense of trying to define things like extraordinary drought. We have mechanisms, we're missing mechanisms, whether they be physical mechanisms like infrastructure, like more like dams, or maybe storing water in aquifers. We're missing those physical infrastructural mechanisms that can help support Mexico's obligations. We're also missing procedural and legal mechanisms that can help Mexico fulfill those obligations in order to provide predictable and sustained deliveries. Mexico, I think, can live up to its treaty obligations, but the infrastructure, the physical and the legal and the procedural, it's missing. Now, under minute 325, the International Boundary Water Commission did recognize that a number of activities that were ongoing. There's a Rio Grande hydrology work group, and there's the Rio Grande policy work groups, and the first one is for developing information and data and modeling, and to exchange that information. And the policy work group sort of oversees that data work group, and also considering policy sort of in the broader basin in terms of water management. But this is the kind of things that were needed, and I was really enthusiastic to see that they added that to minute 325, and I'm hopeful that more of these mechanisms are added, because we're missing that. We're missing these exchanges and cooperative arrangements with Mexico. All that with the background of these misunderstandings. I mentioned the extraordinary drought. Well, we're not sure what it means. It's in both the 1906 treaty and the 1944 treaty, but nobody's ever defined it. And it's unclear. And it's been the source of different interpretations by the two sides in terms of deciding, is it an extraordinary drought or not? Can Mexico meet its obligation or not? If it's an extraordinary drought, then maybe Mexico should be given more flexibility in terms of going to a second 5-year cycle. But nobody's ever defined the term. There's also, I think, a misunderstanding here amongst the public about this, which is actually maybe more important than misunderstanding in terms of the legal community. 350,000 acre feet annually or average. Well, the treaty is pretty clear about average, but certainly on the U.S. side, when you talk about to the irrigation districts, they think it's 350,000 acre feet annually, every year, minimum. And so there's a misunderstanding in what are these obligations in these treaties. Same thing with can you carry the water jets from Mexico into a second and then a third 5-year cycle? There's been discussions about that at a legal and policy level, but on the ground, on the public, there's a complete misunderstanding on both sides of the border. Which waters can be used for Mexico obligations? from tributaries, from storage, from upstream on the Rio Grande, from water in one of the reservoirs. That there's agreements on this at that top level, but it hasn't gotten to the public. And lastly, and I'm guilty of this, you know, I say IBWC, I say the commission, I say International Boundary Waters Commission, but very often it's unclear, who am I talking about? Is it that top level binational body, or is it the individual sections? There's a Mexico section and a US section. Which one is the one that we're talking about when we're saying the commission or SILA or IBWC is taking action? I think this is something that needs to be clarified, not just at the top level, but on the ground with the public. Ultimately, there's a significant lack of trust here, and it goes both ways. On the U.S. side, on the Mexico side, especially at the lower levels, but also at the top levels. I think that between CONAGUA and the Foreign Ministry, and also the U.S. State Department, they're not always seeing eye to eye. They're not always understanding each other, and they also have these different interpretations of the treaty, and that result in disputes. There needs to be more that has to be addressed on trust issue to ensure and to support Mexico water delivery. So this is something that I think is going to be one of the big issues into the future that I think we're going to have to deal with. Related to this, and I mentioned this, that the public. There's nothing in the U.S.-Mexico relationship, whether at the treaty level or at the IBWC Commission, SILA level, or any level that integrates as a formal matter public participation. I think this is a huge shortcoming of the legal system, the policy system, because decisions are making at the top, and nobody knows how or why or what's the justification or what's the background, and people are getting upset. Look what happened in 2020 when Mexico, and I should say CONAGUA and SILA decided to use some of the water from its tributary from dams within Mexico to pay off the water debt that Mexico had to the U.S. And the farmers in Mexico were up in arms. In fact, they were literally up in arms, and they were trying to take over one of the dams. Mexico sent out the National Guards, the troops, and unfortunately, there was loss of life even. So the lack of an inclusion of people on the ground in the at least information stage, if not actual decision making, I think this is a legal and structural deficiency of the relationship in the treaties, at the commission level, and just in general, the relationship between the two countries. There's an exception, and that is the Colorado River minute 319 to 323. For those minutes, there was really fascinating level of engagement with civil society on both sides, which achieved those 2 minutes. And I think these are probably two of the most successful minutes in the history of the U.S.-Mexico Transboundary Rivers relationship. And I think that there's lessons that can be learned from those scenarios. Now, whether they can be replicated on the Rio Grande, that's something that we have to explore. But I think there's some great lessons that we need to look at and to integrate it. I'd like to see it integrated more formally into the structure, because I do think it's a huge deficiency. Groundwater. There's nothing in the treaties that uses the word groundwater or aquifers or talks about subsurface water. Remember earlier I said the minutes are supposed to interpret the 1944 treaty? This minute, number 242, actually talks about groundwater. And I think it's a valid question to ask. Well, is it interpreting the 1944 treaty, or did it amend it to include the possibility that the two parties will get together? And it says, as paragraph 5 and 6 here, to consult on groundwater, to maybe eventually develop a comprehensive groundwater agreement. I mean, this is supposed to interpret the 1944 treaty. So now there's a question, can they actually, is this an amendment? Does the commission have legal authority to deal with groundwater? I think this is a valid question. We now know that there are possibly as many as 72 cross-border formations that contain groundwater. Are these 72 individual aquifers? This is something that's still being studied, but they're there. There's groundwater. And some of it is actually very linked hydrologically to surface water. So on the Rio Grande, we have quite a number of aquifers that are connected to the river. They either feed the river or the river feeds those aquifers. None of that is taken into account in the allocations based on the 1944 or the 1906 treaty. The aquifers are not connected. This is, in fact, remember I mentioned the case in front of the U.S. Supreme Court between Texas and New Mexico. Exactly the same thing. The 1938 compact they have between those states doesn't mention groundwater, but groundwater is connected to the Rio Grande. And so the question is, can you take out groundwater? Can you pump groundwater as much as you want, even though it affects the Rio Grande? That's the issue now between Texas and New Mexico on the compact. We don't have a case between the U.S. and Mexico on this, but we're pumping. We're pumping on both sides of the river, and it is affecting the water quantity in the river. But there's nothing that addresses that issue. Same thing with the Colorado River. We've got the Mimbres River. We have the transboundary rivers in Arizona, but those rivers don't account for the connected groundwater. I think it's something we need to look at. We need more data and information to build up this knowledge base. As I said, we don't know a lot. We know now about 72 formations, but which way is the water flowing, north or south? What's the water quality? What's the chemistry? How many wells do we have? How much water are they pumping on both sides? We need to develop this information, and I think that's something that's sorely missing. And then back to the point, well, does the commission even have the authority to deal with groundwater? I think that's something that needs to be considered and addressed. All right, finally, the latest hot topic on the Rio Grande. The idea of securitizing, this is for a political science terminology, the idea that you're taking a topic and converting into a national security issue. This has occurred a few times in the past on the Rio Grande, but never to the level that it is right now. What the state of Texas has done here by placing these buoys in the river, and not just the buoys, but also the concertina wire, because this has an effect on the river as a border, whether it's for crossing purposes or just to demarcate the border itself. And because of that, at least on the U.S. side, there has been 2 lawsuits instituted, one by the Department of Justice and one by a local kayak guide, to address this issue. I actually think that Mexico has a very strong argument for its own lawsuit, whether they want to file it in the U.S. court or take it to an international tribunal. Now, of course, I highly doubt Mexico will do this. We have very good relationship. This is going to be solved diplomatically. And in fact, if you recall, before the hearing that took place last Tuesday, it was discovered that 80% of the buoys were actually physically on Mexican territory, and only 20% of the buoys were on U.S. territory. And Governor Abbott had his people jump in the river quickly and move them before the first hearing in the big lawsuit. Mexico has been, I think, very sensibly polite about this situation and trying to let the U.S. deal with the situation. But I do think Mexico has a very strong argument, and I'll talk a little bit about it, but this is a violation of their sovereignty, a violation of treaty law too. Real quickly, the status of the DOJ lawsuit, the Department of Justice. There was a hearing last Tuesday. This was a preliminary here. This is not the final say in the case. The case is going to continue. Preliminary injunction. What the Department of Justice wanted was to require Texas to remove the buoys and possibly also the concertina wire, and not to place anything new on the river until the case is decided. So this was just a preliminary hearing just to temporarily move it. Now, whether the judge will allow it, the judge has not made the decision yet, but that's what we're waiting to hear. There was a deadline on written closing arguments on Friday, so I'm presuming the judge is still reading through and going through all the material. We should know soon whether the judge is going to allow the buoys and the wire to stay in place while the case continues, or require Texas to remove them, at least until the case proceeds. Interestingly, the Department of Justice filed on one issue, violation of the Rivers and Harbors Act of 1899, which is a U.S. law. They did not file an immigration issue. They did not file on sovereignty issues and violation of Mexico. They filed on this, and I think it was really smart of them, because, and if you heard or saw the transcripts of the court case from Tuesday, the judge asked for the parties to present their case. Texas stood up and started saying about immigration and invasion and talks, and the judge said, nope, this case is not about that. This case is about a violation of Rivers and Harbors Act, and that's what it's about. And basically, effectively cut off, and at least at this point, now whether that comes back in another point in the case, at least for now, the judge is trying to focus it just on the Rivers and Harbors Act. I thought that was really shrewd of the Department of Justice to file only on this point, and we'll see where it goes. But real quickly, I'm going to finish off in a minute. Two other issues that I think are really important in this case that nobody has filed yet. I think there's an Endangered Species Act claim here that the U.S. could pursue against Texas. I'm not sure how strong it is, because I don't know if there's any endangered species in the Rio Grande at this location, but that's a possibility. But more importantly, the U.S. has been placed in the position where it is now in violation of the 1970 treaty with Mexico. Texas has caused the U.S. to violate the treaty. And I think the U.S. has a claim against Texas for causing this violation. The boundary is the middle of the channel. As I said earlier, the buoys were 80% on the other side, violating Mexican sovereignty. Of course, Texas fixed that problem, but that still doesn't mean there wasn't a violation. And also, by Texas taking this action, the U.S. is now violating this agreement, because it's not that it allowed, but Texas has done it. But effectively, the U.S. has allowed the construction of these works in a way that may affect the flow of the river. And under the 1970 agreement with Mexico, the U.S. should have engaged with Mexico and explained what was going to be done and alerted them. And the International Boundary Water Commission should have been involved in terms of determining whether this will affect the flow of the river and where the boundaries are, and does this relate to stabilization of the channels, because that's an obligation under the treaty, improving the channels. Is this going to somehow interfere with the stabilization of the channels? None of this was done. U.S., in my mind, is in violation of the 1970 treaty because of what Texas has done. Whether U.S. sues Texas for causing this, I don't know, but this is something that remains to be seen. But I'm going to stop there. There's a lot there that I've covered. I appreciate the opportunity, and hopefully there's some questions. Thank you.
Thank you, Gabriel. I have like 2,000 questions for you, and I'm going to save them all. Oh my God. Yeah, I will try to address some of them, but first I'm going to give the opportunity for the audience to get their questions answered. So there's one here, Madeleine Glickfeld. How binding are the IBWC minutes on the two countries and the states that implement the treaty in the U.S.?
The minutes are binding on the countries. The minutes are binding on the countries. Now, are they binding on the Mexican states and US states? Yes, but indirectly. It's the obligations of the federal governments to enforce it or to get now that becomes a domestic relationship issue. I'm not an expert on Mexico federalism, but US federalism, the US federal government has obligations for foreign relations, for international relations, for transboundary river issues. So arguably the federal government has the right to require Texas, New Mexico, Arizona, and California to abide by these minutes. But of course, that becomes a domestic political issue. So.
Patricia Herrera, IBWC still can be considered as a scientific community?
It's an interesting question. The two commissioners under the treaty have to be engineers, not politicians, not policymakers. So the top now they get ambassadorial recognition, diplomatic status, but they actually have to be credentialed engineers. They have legal advisors, they have policy advisors, and so on. So it is a scientific community, but it's also a diplomatic community. It's a mix. What I really love about the IBWC is that they are technocrats. They first and foremost, they try to solve the problems. Sometimes they act more like engineers and scientists. And I think some of the scientists in the audience might understand what I mean. Engineers try to fix things, right? And they have technical mechanisms to fix it, where scientists are trying to more interpret what's going on. And so IBWC often does more on trying to fix problems, but they still are doing data gathering. They still are collecting information. Where they can, it's a binational relationship. And they try to work with universities to the extent that their mandate allows them. They try to work with the institutions to the extent that the mandate allows them. So yes, it's a scientific community, but it's an institution that is a political institution at its core, run by non-politicians. So it's a hybrid, maybe. And just there was another question, just to maybe add to it. I want to say the commission, el comisión, because when I say IBWC, a lot of people think I'm talking about just the American section. And when people say SILA, oh, that's just the Mexican section. It's one with two offices. But sometimes the American section or this Mexican section implements something within their sphere that is under the single entity. And so this is one of the confusing part, which I mentioned in my slides. You don't always know who is acting. And I think part of it is terminology. And so when I say commission, I try to, that to me, it's like everything, the whole thing. When I see IBWC and I make a mistake all the time, I really want to mean that it's just the American section. And when I say SILA, it's just the Mexican section. But I mix it up and I say IBWC, and and this is a problem that we're all making. We need to have be more aware, or at least explain what we're referring to, the top level or the two sections. It's one entity, but it does have two offices for purposes of domestic implementation and domestic responsibility.
Now, I wanted to raise one topic here. You mentioned trust.
Yeah.
But you also mentioned that there are differences. I mean, Minute 319 and Minute 323 are really examples of trust, right?
Yes.
So would that be, I mean, I don't know, I want to hear your thoughts. Would that be more related to the history between Mexico, California versus the history between Mexico and Texas?
I think history plays a huge part of it. Absolutely. The relationships that the people have, and when I say people, I'm talking about people on the border. there are border communities all throughout, but the border community in California and in Baja is not the same border community that you find in El Paso and Ciudad Juarez. There's different histories, different local experiences that relate to that cross-border relationship. And that does, I think, play a part in trust. But I think I still think that in the Colorado River Basin, there still was distrust at the time, maybe not as much as we have on the Rio Grande, but because they had such a strong stakeholder engagement program, non-governmental organizations, civic groups, municipalities, it helped overcome some of that trust barrier. I think it'll be more of a challenge on the Rio Grande, but I think it can be done. And bringing in all these players at the different levels to engage, maybe even to, I don't know about decision making. I don't know if the commission is ready to go that far. And US and Mexico, I don't know, but at least information sharing and engaging at that level. We on the US side have a bit more of a history and comfort with that kind of engagement at the local level because we have a decentralized water management allocation system. So just by design, we get more public participation than I think in Mexico, where things are much more centralized. And what's the word? The understanding that you as a member of society can speak to the top level people, well, you need a forum for that. You need a place to do it. And you need to have a mentality that your voice is important. We have that to some extent on the US side. I don't know to what extent we have that on the Mexican side. I know that the people in Mexico would like to have a voice. I don't know if many of them believe that they can have a voice, even in the few instances where some forums have been created. And I think this is a culture issue that has to be changed and encouraged and facilitated by both governments and by the commission.
It's pretty interesting, the amendments, the amendment, I guess, question mark, interpretations of the treaty, because precisely minute 323 could be a whole new treaty. I mean, it's really a whole new treaty. It's not interpretation of the treaty. It's really a huge amendment on water allocations of the Rio Colorado to the Mexico side. So I think we've got beyond that point of interpretation, which is okay, right? It's been okay.
Well, so I'm going to put my lawyer hat on here and argue this from a legal point of view. It's not that it's okay. The rule is these are still supposed to be interpretations. But if in any particular issue you create an amendment such as, oh, now they talk about groundwater, they never had authority to talk about groundwater, but they're doing it now and they put it in a minute, as a legal argument, I could argue, I'm not fully convinced of this, but I think this is a good argument. They've overcome that interpretation to amendment gap. And for groundwater, they now have amended their authority to deal with groundwater issues because of Minute 242. Maybe also Minute 289 also has a little provision on groundwater and so on. And so now maybe they do have authority because nobody ever objected. That's the key. Nobody ever objected to it. And when I say nobody, I mean the State Department and the Foreign Ministry, and nobody else anywhere else. And Minute 242 was 1973. So that's an argument for why they might have authority to deal with groundwater. So Minute 323, maybe nobody's objected to that minute. Maybe some of the points in there have gotten to the level of authority of the commission. But this is, I'm just making an advocacy legal argument, not a recommendation or or anything like that. But I think that that's something that needs to be further explored, because I think that they need to have groundwater authority. I think they need to have more authority over environmental flows. I think they need to have authority over climatic changes and define extraordinary drought and all those. I don't think we need another institution. I think IBW or the commission should be the one doing this, and just expand its authority.
As long as both countries agree on it, it seems to be working. So
yeah.
Why not? So the why not is not there. Okay, I'm gonna go with Mauricio Reyes. It seems increasing water use in Mexico and to a lesser extent in the US depends strongly on the trans-border economic activities. For example, Chihuahua and other border states is a large producer of forage, large water use, which is mostly sent to feed US cattle, 90%. Any thoughts on how could a sustainable scenario under the treaty include these kind of factors?
I don't know that the treaty needs to be that detailed, because now we're talking about how the countries should use the water that is being allocated to them. The treaty at a top level decides how much water each country should get, but it's for the country to decide, should they use it for forage and ship it all to the US, or should they use it for something else? So this becomes a national decision on Mexico's side. And I don't think the treaty needs to get engaged in that level of decision making. It doesn't mean that there are systemic problems and problems with what you're suggesting here, using all this water to produce feed for cattle in the US. I agree that there's something doesn't sound quite, right there, but that becomes a trade issue. That becomes a national decision issue.
I'm going to read a comment by Sally Spinner related to the conversation we were having about, amendments and all that, because I think it's worth considering, coming from her, from IBWC. IBWC considers minutes to be implementing agreements as well as interpretations. We did consult with the Senate Foreign Relations Committee prior to signing minutes 319 and 323. There was no indication during that consultation that they considered these agreements to be amendments requiring Senate ratification.
So
thank you, Sally.
No, this is great, and Sally, thank you for that, and also for your other comment I saw, because you're on the ground, you're there on a day-to-day basis, and so you would know better. But I find the language interesting. This is implementation of the treaty. So we have interpretation of the treaty, we have amendment of the treaty, we have implementation of the treaty. What do all three of these things mean? And if it's implementation of 1944 treaty, you can argue, okay, it's not amending, it's just implementing in a different way. So that goes back to interpretation. But I just find it interesting, and sometimes we get into these semantics. Sally knows this better than I do. And how this works. So I'd be interested to know, you mentioned consultation for the 319, 323. Was there consultation for 242 at that level way back in the 1970s? I know there were some discussions, but I don't know if there were discussions with State Department and Senate committees and so on. I'd be interested to know that.
Thank you. Another one here quickly. Is there any supranational legislation other than the Paris Agreement that addresses legal obligations throughout the entire watershed hydrological cycle, including the atmospheric water processes affected by human-induced economic activities such as aerosols and greenhouse gases?
So I'm reading that the Paris Agreement meaning the climate change.
I guess so.
You're asking at a global level? I mean, we've got the Kyoto Protocol, we've got some other agreements and arrangements on climate change. For the Rio Grande Basin, there's nothing specific to that. No.
Yeah. How significant are upper Rio Grande water appropriations in New Mexico, Colorado, and parts of Texas to binational water sharing?
Yeah, it's a big issue. Remember, the U.S. is obligated to deliver 60,000 acre feet to Mexico at that point where you have basically where El Paso and Ciudad Juarez are located. Well, to have 60,000 acre feet, that means Colorado and New Mexico have to give up a right to 60,000 acre feet so that the U.S. can then store it and deliver it at the right time. Of course, there's that proportional reduction provision that if there's a drought or infrastructure problems, then we reduce on both sides. But we reduce the U.S. side on the upper basin, which then has to be divided up between Colorado and New Mexico based on their own relationship. But that means New Mexico and Colorado have to use less. And so that does affect directly what the U.S. is obligated and is supposed to deliver to Mexico. So yes.
And if I'm not mistaken, and I'm glad Samuel is here, I think that 60,000 acre feet of water is just 10% of river flow that comes from Colorado to the border. Is this correct?
So the overall Mexican, the allocation for Mexico?
Yes.
I think it's 8.5.
8.5%. Yeah.
Yeah.
But I think, but in what year?
Oh yeah, of course. That is so basically
1906. Yeah.
So and actually I think it is kind of like yeah, what you're saying, kind of magic water, because so 7.5 to the upper states, 7.5 to the lower states, and 1.5 to Mexico. So in theory, there are 16.5 available, right? But it is in theory, because it rarely happens. Yeah. So basically, it's dividing 1.5 over 16.5, and that will be the exact number. But the reality is that in the last 20 years, it's just going down, down, down.
But that's on the Colorado. That's on the Rio Grande. When we say 60,000 acre feet, I mean, is a
the 1904, the 1906 convention.
Oh, the 1906. Okay.
Yes.
No, that is like 8%. So
it's 8%. Yeah.
No, so actually, no. Let me correct that one. So 60,000 acre feet, and the volume of water that used to flow in El Paso was about 1.8, 1.7 million acre feet. So it's 1.7 million compared only to 0.060. It's a small amount. On that side is super small. I can do the math right now, but it is very small.
It's very small, but how much water actually gets to the El Paso? If you take the 60,000 acre feet, how much gets to El Paso today? It's almost zero. So, so back to the question, you know, how much impact does it have? Colorado, New Mexico, it's a huge impact, and because the U.S. is only required to deliver 60,000 acre feet, and usually that's all it delivers, and nothing more comes to. I mean, from El Paso and Ciudad Juarez downstream to, I don't know how many miles, Fort Kittman, it's dry, almost always dry. Right now you have the storm that I heard kind of filled up the river a little bit, but it's usually completely dry in that area until you get to some tributaries that start to fill up the lower Rio Grande.
Just to follow up on the question you mentioned, on minute 242, Sally responded. Thank you, Sally, for being engaging. Minute 242 was a separate process outside of the IBWC, led by Ambassador Brownell. Brownell, who was appointed by President Nixon to negotiate and resolve the Colorado River salinity dispute. So there you have it.
Interesting.
We have a lot of alternatives to Simplao.
Is that an amendment? Is that an amendment, or is that just an interpretation? You know, it was negotiated separately, but that's interesting. Yeah, yeah.
And just for the clarification,
flexibility is the rule. Flexibility is the rule, apparently.
Yeah.
So those 60,000 acre feet per year is 3.7% of the natural flow there. And we have to remember that for that specific area, Elephant Beauty Irrigation District, EBID, and El Paso County Water Irrigation District and Hotspit, those three, they take about 700, yeah, I would say 600 to 700,000 acre feet. So it is a small amount what Mexico takes, and it was that some other people, some other historians have called it. Actually, if you read the title, is equitable distribution of water between the Convention of 1906, equitable distribution of water, and many on they have a fight or argue about it.
Is it equitable? Yeah, yeah, yep.
Another interesting here from Alicia Catalano. Is there any indication about the quality of the allocated water?
Not directly. In the 1944 treaty, it doesn't specifically talk about a certain quality of water that must be delivered. But we have seen quite a number of minutes where the commission has taken action to address water quality issues. Just an example, we'll go back to minute 242. It has those two provisions on the groundwater, but the rest of the minute is actually about the salinity of the Colorado River that's being delivered to Mexico on our west coast. And so there's different examples where they have dealt with water quality, and I think that's one of those issues that has been interpreted into the 1944 treaty that they do have authority to address it. Now, it's not just regular pollution. I mean, you've got municipal waste, municipal flows, you've got agricultural runoff, you have all sorts of contamination issues. And I think that this is something that the commission has taken on that probably not as far as some of us would like to see, but they certainly have done a valiant job in pushing those issues forward.
Thank you.
Hey, Eric, before actually moving forward, so you mentioned about what was the authority or the legal umbrella to make sure that states follow federal law or international law. And at some point I had a conversation about this with Luz Manaba, so I don't want to take credit for something that I didn't mention, but basically she mentions that on Mexico's constitution, Article 133, it is the explanation, and basically the laws, the constitutional laws and treaties and international treaties have the same legal standard. And basically it says that, I mean, it's not that a state cannot follow the constitution. Yeah. And it's Article 133, and that's how they can implement it.
And Mexico has that provision in their constitution, and the U.S. does not. And now, that is a challenge on the U.S. side to, the enforcement mechanism on the U.S. side is by the federal government having to sue the state, just like they're doing on the Rio Grande issue. But it's more complicated on the U.S. side.
Mekonnen, we have monopolized the conversation here because it's very passionate. We can be here forever, so please take over. I know you have questions.
Yeah, learning a lot. Very, very interesting discussion. Thank you so much. Well, I'm going to, Gabriel, you are also, an expert on several river basins globally. So I'm going to ask you a general question, specifically as it relates to the global south. So one question is, what are the lessons that the Global South could get from here? But also, are there lessons that, Colorado or Grande can get from other places globally? And as you mentioned earlier, I think that the two major issues are there's the diplomatic part, political part, but there's also the scientific part. In some basins, maybe the political issue may be, much more important. In some other basins, they have figured out the political issues, but the scientific issues are maybe missing. So if you could collectively, take all this into account and share with us your experience of, in general, how do transboundary river basins across different waters, how can they cooperate with each other, etc. Thanks.
Yeah. So there are examples around the world where you have binational and multinational basin organizations that functions effectively. And I'm thinking about on the Senegal River, for example. It's a really they have a very strong history of cooperation and organization. And there's a few other places around the world where you have that. Certainly in Europe, they have very strong institutional systems where the countries can cooperate over the management of the basin. Unfortunately, you also have conflicts in many parts of the world, certainly in the global south, as you mentioned, that kind of creates challenges to cooperation. And this is the point that you raised in terms of a technical organization versus a political organization. I am very much in favor of having technocrats run these kinds of organizations because their focus is usually, not always, but usually more on the science and the engineering and the technical issues than on the broader politics. So you think about the broader politics between U.S. and Mexico, drug trafficking, immigration. I mean, there's so many issues that are going on that it kind of clouds the picture of, well, wait a minute, we're just trying to figure out how much water each side should get. And then Mexico has a water debt. How do we deal with the water debt? Or we have climate change and or the river moves. Those are issues that I think can be resolved and should be resolved sort of not necessarily insulated from the politics, but at least somewhat separated from the politics. And imagine before we joined with all our audience, we brought up the Nile Basin or the Tigris and Euphrates. I mean, there's some political hotspots there. Imagine if they could address the river basin management without the broader politics. And by technocrats, people who understand water flow, water management, water policy, ecosystems, climate change, hydrology, hydrogeology, the related groundwater. If they would be the ones to sort of come up with these agreements that can be put in political terms later. I think things would be much better. So I definitely support the idea of a more technocratic approach to basin management and basin institutions. The other thing that I think can be learned from the U.S. and Mexico experience is the Minute system. We've talked a lot about it. I don't know of any other basin that has that kind of interpretation, amendment, whatever you want to call it, system. And it really allows for these old treaties to have a longer lifespan. Now, these treaties may not be fully functional as we would like based on new conditions, but they give them a longer lifestyle, and they allow them to be, the flexibility to do more and to address new problems and new situations. So I think that's something to consider.
Thank you so much.
And if Sally's there, because she also can help out on some of these is the implementation, how the minutes have helped us out to implement on the ground and to get things addressed. that are occurring at the border without actually going all the way to Mexico City or all the way to Washington, D.C. So I think that's, and yeah, I agree. This system is a really a living document, or it is a living experience, which I think is great.
Just a quick question here relating to water efficiency. Water use in both countries are mainly for agriculture, irrigation. Are there discussions about improving water use efficiency or diversifying cropping systems?
Those are domestic issues. That's for Mexico and the U.S. to decide at a domestic level. Now, at the commission level, they can certainly talk about improving the delivery mechanisms. And for example, on the Colorado River, they did this in the context of minute 318, 319, and so on, where you know there was an earthquake in Mexicali in 2010, 2011, somewhere around there, and the infrastructure, I mean, it was really destroyed. And they came up with interesting and fascinating financing mechanisms where the old infrastructure had been leaking, so they lost a lot of water. Well, they came up money from the U.S. private sector and non-governmental sector to fix the infrastructure in Mexico, but to also provide water savings because it was more efficient. And it was better for the farmers because then they can have more water. But at the same time, some of the water savings would then transfer to the U.S. because it was the U.S. side that the private sector, the non-governmental and so on, it was water that Mexico would have lost through the poor efficiency infrastructure prior to the earthquake, but now they wouldn't need because they're more efficient. And so you can do these kinds of interesting exchanges and collaborations that improve the delivery infrastructure. Now, in terms of the actual use, what you use it for, that becomes a domestic issue. It's for Mexico, it's for the U.S. to decide within their own systems and procedures what they want to use the water for.
Since you're legal, Patricia Herrera, from your legal perspective, the International Water Convention can help reduce Mexico's asymmetric water relationship on this binational river.
Yeah. So this is an interesting question, but it's also based on perspective. Is there an asymmetric water relationship in this binational river? You have to think about it from a couple of different approaches. One, okay, we have a different developmental levels. So yes, the U.S. is much more developed, more resources. Is that the asymmetry? Or is the asymmetry that the actual allocation, how much water Mexico gets versus how much water the U.S. gets? You have to think about it in terms of two countries under international law coming together and creating a treaty. Under international law, they're equal. Yes, there may be more bargaining power and more resources on one side, but they both agreed. And they both agreed to these allocations. Now, why did they do that? Why would Mexico in 1944 agree to this allocation? Usually it's because they have other things on their mind, such as trade, such as crops, such as products that they want to sell to the U.S. So there's a lot of things that go into these treaties that has nothing to do with what looks like asymmetric relationship at the end. They're both at the same level. They both agree. So this is a subjective decision of the countries to decide this is how much water we're going to allocate. And so it's hard to say that that's asymmetric if they agreed to that relationship. And again, why did they do it? Well, because probably they had other things that they were negotiating, not just the water. They were probably negotiating at the same time delivery of trade and goods by trucks and allowing Mexico truck drivers to drive on U.S. roads, or delivery of increase of imports of agricultural produce from Mexico into the U.S. And so, you know, you're never negotiating just one topic. It's rare. I mean, you, the negotiator, might be negotiating just that water issue, but the people behind you at the federal, the foreign ministry and the State Department, they're thinking about the water relationship, the drug trade, the immigration, the trade of wheat, trade of tomatoes, the trade of auto parts, and they're playing with all of these at the same time. So I don't think there's an asymmetric relationship here. I think there's certainly asymmetric in terms of resources and capacities and so on. But in terms of the treaty, I think it's equitable because the parties decided it is equitable. Samuel, you raised the point on the 1906 treaty because it has the word equitable in it. The parties decided it's equitable when they entered into the treaty. Now, for us, it may not look equitable, but the parties decided it was equitable. Should we go back and say, you guys made a mistake? Or it was decided unfairly? I mean, that's the kind of, that's what we would have to engage in, that kind of a discussion, which I don't know how productive that is.
And if I may add, in volume, and Sam will correct me if I'm wrong, in terms of volume of water between the two basins, Mexico gets more water than the US.
Yeah, so basically, so there are, it was divided almost like 37%. So of all the water below Fort Whitman, it is 37, I think 40% of the water is used by the US. 63% might be used by Mexico. Now, in terms of volume, it's a small amount. And so that asymmetric power. So also something to mention there is that when water is delivered to the US, 2 units of water is delivered to Mexico's farmers along the border. So it was also a mechanism to actually make sure that people on the Mexican side get water. I always say that if it goes wrong for the Texans, it goes twice as wrong or twice as bad for Mexico's farmers. So it is now. But here is kind of half of the picture. The other half is how Mexico receives water on the Colorado River. So if you look at that one from American point of view or US point of view, it's like it is asymmetrical because less than 1% of the basin is on Mexico's territory, and Mexico receives 8.9% of the volume, and it's larger. So you receive less in percent, but more in water. And on the Rio Grande side, you are providing water to the US, but it is a smaller amount. So in terms of the numbers, I think it was well designed. I was looking at the attendees. Ramon and I, we work on the Pecos River, and I think it was miscalculated. So those numbers have to be reviewed. But nonetheless, it is always what Gabe is mentioning. Like at that point, with the best of the knowledge of everyone, that's what it was meant. I will put on the chat on our response the article from Oribe Alba, which is basically when he explains how it went off, and also the quote for a book that from Enrique Escoido. Those the book of Enrique Escoido, you can get it, buy it. Like it was just released once or published one by UNAM. That is an excellent book, and it really is the work, now the description of a lawyer when they were negotiating the treaty, and it tells you step by step all the different historic content, and then why decided to do it in that way. That one is amazing on both ends, on the Colorado River and on the Rio Grande. So I'll type all of those.
Yeah, but it's interesting. Just one point here. Again, you're not negotiating one thing, water on the Rio Grande. 1944, they were negotiating water on the Colorado. They were going to go on Tijuana. They were on the Rio Grande, and then percentages. And I mean, so it's hard to say that it's inequitable or unfair or asymmetrical. There's so much more that went into these negotiations behind the scenes and why they did these things in a certain way. And this happens, in Europe, in Africa, in Asia, Latin America, it's water doesn't usually get its own agenda without anything else. It's taken for granted. And so water is typically, yeah, okay, we have to have a water agreement, but if we'll give you this much water, but you've got to give us this much on trade, and you've got to give us this much on immigration, and this you get, and it becomes just one issue in the negotiation. Now, you may get a water treaty, but that water treaty wasn't negotiated just on its own. This is probably why the Nile River Basin relationship is so challenging, because it is so focused on water and not much else. This is now Ethiopia is trying to bring in things like electricity. We'll give you electricity, we'll give you flood protection and so on. But it's so challenging when you have so few things and you're just focusing on water. Water is emotional. And when somebody says you're going to get less water, you become defensive. And unless you can get other things in exchange, like in the US we say apples for oranges, right? It's not the same thing. Okay, maybe, but when it's water for water, it becomes emotional, and it becomes more challenging, I think.
And I guess with that, it's 12:32. Gabriel, I'm sorry, we should pay you.
My lawyerly fees.
Thank you. It was as always an honor and a pleasure to have you with us.
Thank you for having me. It's really a delight. And thank you for everybody with the questions. It was really, excellent questions. And I'd love, if anybody wants to, continue the conversation beyond, I'm happy to do so on email and so on.
And also thanks to Gabriel, Rosario, Mekonnen for organizing this. I think this is the last one, right?
Yes.
So
yes.
Definitely a big hitter for ending our sessions. And yeah, thanks everyone for joining us.
Yeah, Sam, we should do this often. This is such exciting collaboration. We learned a lot, and what the best way to end the presentation. Thank you so much, Gabriel and Sam and Rosario. And thank you also to our audience who have been with us throughout the 6 webinar presentations. And going globally in about 2 weeks from now, we should send out the announcement soon. We'll start with another session focusing on Guadiana River Basin between Portugal and Spain. They have interesting stories to share. So we'll see, hopefully, most of you in about 2 weeks from now. So thank you so much. Thank you.
Thanks, everyone.
Thank you. Thank you. I'll see you. We shall see you.
Bye.
Yes.